I call the Honourable David Parker.
Thank you, Mr Speaker. The Labor Party supports the Evidence Amendment Bill. Can I thank the Select Committee for the work that it's done? Can I also place on record that I think that this is an area that Amy Adams is doing good work in. I do think she genuinely has concerns about the levels of violence, particularly against women in society, and she's determined in her period as Minister of Justice to try and change the settings in a way that bring more of these instances to court for resolution, but also to deal with the matters in other ways so that we have a reduction in the level of violence against women and children in New Zealand. And I commend her for doing that. I'm sure were it a Labor member in that office, they would be similarly motivated to improve this problem that we have in New Zealand. I, for one, don't accept that all of the increase that we have in domestic violence shown by our statistics is caused by additional reporting. I think we've got a long enough history of being able to report domestic violence in New Zealand to actually have to face the uncomfortable conclusion that in New Zealand in recent decades we have had increasing rates of violence against women and children, and I think that shows up now in the statistics. I don't accept the proposition that the terrible statistics that we now have in relation to domestic violence and violence against children are because it's being reported properly. I think that's part of the situation, but I also think it's partly because we do have an appalling record in respect of those issues in New Zealand. Indeed, you know, there are so many ways in which New Zealand can hold its head high in respect of outcomes, be they socio-economic or environmental, compared with other parts of the world. But in terms of our record of violence against children, we do have a terrible record. So I support the changes that are being made in respect of evidence, particularly in trials relating to sexual violence, and I think the proposals that are made by the bill here are proper. I want to highlight one issue that's been picked up by the Select Committee, and that relates to what care we have to take when it comes to the admissibility of hearsay evidence. It's very easy for us in this Parliament to say, oh, we've just got to make things easier for the prosecution in order to get convictions. We must always guard against injustice. The legal system in New Zealand, and indeed in all of the countries that have followed the Westminster model, and in countries like the United States, which I suppose broadly is based on that model, albeit going back some centuries further, and it's departed from it a little bit more. In all of those countries, we say that it's better that a guilty person go free than an innocent person be found guilty. That's essentially why we have we have a higher standard of proof in criminal prosecutions that have to be proved beyond reasonable doubt compared with a civil prosecution, because a criminal prosecution can end up with a stain on the person's reputation and, in serious cases, the loss of their liberty. It can effectively ruin their lives if they are found guilty wrongly. Now, I'm sure there are some limited cases in New Zealand where people are found guilty when they are innocent, but more often than not, we have people who are guilty found innocent. And that's where the balance should lie, because we should, in Western societies, be holding firm to this principle that it is, you know, we've got to be very, very sure before we impose the coercive powers of the Crown to penalise people who've been found guilty of crimes. Now, where does the rule against hearsay fit into that? Well, there are some very sound rules of evidence that actually make sure that prosecutions against people are sound rather than just assertion. One of those rules is the best evidence rule, and that's a rule that effectively the courts say that, look, the evidence that we will hear in order to convict someone of a crime, and it's actually the same in this respect in civil proceedings as well, the evidence that's to be tendered is the best evidence that is available. So if there was a secondary source of evidence that is not as good as primary evidence, then the court ought not to hear the secondary evidence, they ought to hear the primary evidence. The rule against hearsay is in some ways a subset of the best evidence rule, and it says that, where there's primary evidence we should hear it. We shouldn't just hear someone giving hearsay evidence of what someone else might have said. There are a number of reasons for that. One is the best evidence rule that I've said, but it's also very hard for an accused or a judge, for that matter, to be sure that hearsay evidence is true, because the person who is giving the evidence about what they heard didn't hear the original evidence that was given, and therefore can't be challenged as to the details of that evidence or as to the demeanour of the person who made the original statement, because they weren't there, they sometimes weren't there to hear it. So now there are some exceptions to the rule against hearsay, and they're practical and they're necessary. For example, a statement that is made by someone before death and they're no longer alive at the time of a prosecution, obviously they can't be there to give evidence, and so there are some limited exceptions against the rule to the rule against hearsay in respect of statements of people who are dead. Therefore, the best evidence of that dead person is never going to be available to the court, and the court will, in some instances, hear hearsay evidence as to what the deceased person said prior to their death. Well, we can understand that. That's still the best evidence available. Obviously, it would not be as good as the original evidence, but I'm sure that courts and judges can give appropriate warnings to juries in respect of the problems that evidence, or the limitations of that evidence. There are also exceptions relating to business records, and this evidence amendment bill tried to make that clearer by saying where there are standard business records, then those business records can be admitted without further first-party proof that they are correct, and that they can just be relied upon as being accurate as to what they show, rather than there have to be some primary evidence tendered to prove that they are correct. And that was another rule, exception to the rule against hearsay, and that was tried to be cleared up by an amendment brought forward by this legislation, but as the Select Committee found, no doubt on the basis of submissions, probably from the Law Society, and if it was from the Law Society or the Criminal Bar Association, can I thank them for their submission? I expect it was. I wasn't sitting on the Select Committee, but you know, as a member of that profession who pays my annual practicing fee, I'm really so pleased that the Law Society coordinates this. Actually, those people who make those submissions aren't paid, but the Society does. The Law Society does a fantastic service to New Zealand when it gets into the detail of these things, and they pointed out that the definition of what was a business record was so broad as to possibly include some police statements that ought not to be admissible as a business record, as an exception to the rule against hearsay, and in respect of that sort of evidence, it ought to be provided by the police in the best, in accordance with the best evidence rule, and not have an exception to the rule against hearsay. And so the Select Committee identified that as a problem with the bill as introduced to the House. I think they fixed it by the amendment to Clause 7 of the bill, which rewords Clause 7B to say that this exception does not include a police record that contains any statement or interview by or with an eyewitness or a complainant or any other person who purports to have knowledge or information about the circumstances of the alleged offending or the issues in dispute in a civil proceeding. So they've made it clear that a witness statement that a policeman takes down cannot be tendered in evidence, because that witness statement is effectively a hearsay report by the policeman of what they heard the witness say to them, and in that situation we should have the witness before the court giving primary evidence, not a police record which is hearsay.
I call Jackie